Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. Continuing with our endeavor to study and understand the various legal proceedings under the Act Insolvency and Bankruptcy Code 2016, I once again welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the Act IBC 2016. So friends, insolvency professionals are the key figures to navigate through the complex legal and financial landscape of insolvency. And while in performance of their duties as IRP, RP, and liquidator, they have to conduct various activities, which include, among others, to pursue litigations which are in the company and to verify all the claims against the company, and also to deal with competing interests of all stakeholders. So, friends, let us today discuss a landmark case which I'm sure will assist all insolvency professionals while performing their duties as IPs. So, friends, this is the case wherein the interplay between arbitration agreements under the Arbitration and Conciliation Act 1996 and the Indian Stamp Act 1899 is there. It is the case of NN Global Mercantile Private Limited versus Indo Unique Flame Limited, which was decided on the 13th of December 2023 by the Honorable Supreme Court of India. So on 13th of December 2023, a 7-judge bench of the Honorable Supreme Court, while answering a reference in the matter titled Interplay between arbitration agreements under the Arbitration and Conciliation Act 1996 and the Indian Stamp Act 1899, has settled the law regarding the validity of an arbitration agreement where the underlying contract is unstamped. The challenge before the 7-judge bench was to harmonize the provisions of the Arbitration and Conciliation Act 1996 and the Indian Stamp Act 1899. Now let us see the factual background of this case. Now, whether an unstamped arbitration agreement is valid and capable of being enforced, the peculiarity arises out of the interplay of 3 different statutes. That is the Arbitration and Conciliation Act 1996, that is the ANC Act, the Indian Stamp Act 1899, and the Indian Contract Act 1872. Now, there have been varying arbiters of the Honorable Supreme Court on this legal principle. Let us see how it has been like. On 20th of July 2011, there was this case of SMST Estates, wherein the appointment of an arbitrator cannot be founded upon an arbitration clause that lacks proper stamping in an agreement, which is mandatory for registration or subject to stamp duty. This was the judgment given by the Honorable Supreme Court. Then on 10th of April 2019, in the case of Garware Wall Ropes, it was upheld the judgment of the SMST Estates. Further, on 14th of December 2020, while in the case of Vidya Drolia, once again, the Garware Wall Ropes judgment was upheld. Now, on 11th of January 2021, NN Global Mercantile Private Limited versus Indo Unique Flame Limited, now which is known as NN Global 1, the arbitration agreement would not be rendered invalid, unenforceable, or non-existent, even if the substantive contract is not admissible in evidence or cannot be acted upon on account of non-payment of stamp duty. This was the judgment delivered, which was further referred to a larger bench. Further, on 25th of April 2023, the NN Global Mercantile Private Limited versus Indo Unique Flame Limited, once again, came to be known as NN Global 2. In this, by a majority of 3:2, it was held that the unstamped arbitration agreements are not valid in law. Now, this was done by a 5-judge bench. Now, on 13th of December 2023, there was a revisit of NN Global 2 by the 7-judge bench, wherein The Honorable Supreme Court, in its quest to answer the issue under consideration, harmoniously constructed the ANC Act, the Stamp Act, and the Contract Act, and in the process rendered findings on the following legal principles. Now, what were the issues before the Honorable Supreme Court? Number one was admissibility versus enforceability of an agreement. The Honorable Supreme Court differentiated between the inadmissibility and voidness of an agreement. The enforceability of an agreement, as per Section 2G of the Contract Act, pertains to an agreement not enforceable by law, that is, a void agreement. Whereas the admissibility of a particular document refers to whether or not it can be introduced into evidence. An agreement can be void without its nature as a void agreement having an impact on whether it may be introduced in evidence. An agreement falling foul of Section 35 of the Stamp Act for either not paying duty or paying insufficient duty is rendered inadmissible and not void, the non-payment of stamp duty being a curable defect. Now let us see the difference between a special act or a general act. Now the Honorable Court provided the following considerations to identify the special act from the general acts. The subject matter of the acts, along with the particular perspective described as the focus of the case, and whether the jurisdiction of the court has been ousted in terms of the procedure prescribed in the special act. It was observed that in the context of the case, the ANC Act is the special act, as the ANC Act is a self-contained code. And when a self-contained code sets out a procedure, the applicability of a general legal procedure would be impliedly excluded, and such provisions of other statutes cannot interfere with the working of the ANC Act unless specified otherwise. Now, the issue in focus or from the particular perspective is whether an unstamped arbitration agreements are rendered unenforceable, and not all agreements. Section 5 of the Arbitration 5 Act contains a non-obstante clause, and thus sections 33 and 35 of the Stamp Act cannot take precedence over the ANC Act in Section 8 and 11 proceedings. Section 11(6)(a) has confined the scope of examination by the courts to the existence of the arbitration agreement, which is juxtaposed to Section 33, subsection 2 of the Stamp Act, which existed prior in time, which requires examination on the touchstone on adequacy of stamping. Thus, the Parliament did not contemplate the courts under Section 11 of the ANC Act to undertake the examination required under Section 33 of the Stamp Act. Section 33 and Section 35 of the Indian Stamp Act, whether they are directory or mandatory. Now, the Honorable Court observed that in order to adjudicate whether the caption provisions of the Stamp Act are directory or mandatory, the following considerations are relevant. Contextuality, interplay, and intention of the statutes in the context of such statutes. Then scope, nature, and design of all these statutes, which appear to operate simultaneously. Then consequence of such interpretation, including the impact of such interpretation on the other provisions. Then the consequence of non-compliance of the provision and impact on the object of the legislation by such interpretation, furthered or destroyed. The next aspect is the interplay of the ANC Act, the Stamp Act, and the Contract Act. A harmonization was created. The analysis of the Honorable Court was driven by the principle that the issue is not whether the agreement containing the arbitration agreement is to be impounded or not, but what is the relevant stage for the same. The court based its findings on the following major principles. Number one, principle of minimum judicial interference. One of the main objectives of the ANC Act is to minimize the supervisory role of the courts in the arbitral process. Party autonomy and settlement of disputes by an arbitral tribunal are the hallmarks of arbitration law, and Section 5 is the embodiment of this principle. Section 5 is of aid in interpreting the extent of judicial interference under Sections 8 and 11 of the ANC Act, as Section 5 contains a general rule of judicial non-interference. Further, Section 5 contains a non-obstante clause which limits the extent of judicial intervention in respect of matters expressly provided under the ANC Act. Next is the doctrine of compes comptes. The doctrine of competence allows the tribunal to decide on all substantive issues arising out of the underlying contract, including the existence and validity of the arbitration agreement. Section 16 of the ANC Act recognizes the said doctrine, as Section 16 empowers the arbitral tribunal to rule on its own jurisdiction. Now, if you look into the examination of the existence and not validity of an arbitration agreement under Section 11, subsection 6A of the ANC Act 1996, the Honorable Court in NN Global 2 relied upon Section 11, subsection 6A of the ANC Act in order to reach its conclusion that a contract must also, needless to say, fulfill the requirements of the Contract Act. The Honorable 7-judge bench, disagreeing, stated that a plain reading of the provision confines the examination to the existence of an arbitration agreement and accordingly limits the jurisdiction of the courts to appointment of an arbitrator. The examination as to the compliance of the rigors of the Contract Act were left with the arbitral tribunal under Section 16 of the ANC Act. So, friends, we conclude that the Honorable Supreme Court held that an unstamped or inadequately stamped agreement is inadmissible but not void, and the same is therefore a curable defect. Now, the question of law before it is whether an unstamped arbitration agreement particularly is rendered unenforceable pending the payment of stamp duty so as to interpose a bar on the referral court to refer the parties to arbitration, and not whether all agreements generally are rendered unenforceable. Accordingly, the Honorable Court held that the Arbitration Act, being the special act in view of Section 5, which is a non obstante clause, read with Section 16, comptes comptes, and thus would prevail. Any objections in relation to stamping of the agreement would fall within the ambit of arbitral tribunal and not under Section 8 and 11 of the Act. So, friends, we see how the courts are really trying to expedite all the processes while ensuring justice to all stakeholders. So, friends, I trust that you find this both enlightening as well as engaging. So, for further insights into such key pronouncements under the Act IBC 2016, please like this video and subscribe to my YouTube channel. So, thank you very much for being here today with me. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.